It's an honor to be here with this esteemed panel. I'm going to talk a little bit about what I do, what I've done, and what I've started to work on most recently. I came to Cato about 11 years ago, and I worked in the Center for Constitutional Studies for fellow presenter Ilya Shapiro here in the audience. A few years ago, I moved over to the Project on Criminal Justice, where I ran a website we called policemisconduct.net. We have 18,000 police agencies in the United States. There's about 1 million police officers, and there's no central database for crimes they commit, misconduct that they do. And so what we decided to do is collect the news stories of these individuals and track how their cases move through the system, whether it's just administrative procedures like, suspensions, losing vacation days and that sort of thing, whether they're sued and whether or not that's successful, or whether or not they are criminally prosecuted in the system. We did that for a couple years, thousands of cases a year, and it turned out that the police are not really held accountable for what they do. And that has a couple of different impacts on the community. First of all, when they commit crimes that are unrelated to what they're doing in policing, which is what they're usually arrested for. It's usually driving drunk or domestic violence. And you see very often that they are absolutely let go. One police department in Connecticut actually, on its application forms, said, would you arrest a police officer that you pulled over drunk, and when you found out it was a police officer, would you continue with the arrest or would you let him go? The police department rejected all the applicants that said they would continue to arrest the officer because he didn't think that was true. That sort of mentality that a police officer cannot be held responsible for doing something that would land any of us in jail is absurd. We cannot hold police to a lesser standard than everyone else. We have to hold them to a higher standard. Now, I moved away from police misconduct into policing policy about 9 months ago. I'd worked on police policy already, but police misconduct had been my focus. And the thing is this unaccountability of police officers has translated into the policy realm. Not only are they not being held accountable for what they're doing when they're off duty, they're not being held accountable for what they're doing on duty. And so if they're hurting people, if they are violating people's rights, and they are not, and the community knows this, and they see the same police officer back out on the street the next day, that delegitimizes the police force. That makes policing harder. This is why we've called this program self-defeating policing. So much of what we've asked the police to do actually diminish or corrupt the relationships they have with the communities, and particularly the communities that need it most. We know, I don't know how much about American geography you know, but most of our American cities are still racially segregated. They're not segregated by law anymore, but they're segregated by policy. Some of this stems from government loans that were implemented in a discriminatory fashion about 50 years ago, but those legacies live on. And we're not talking about just in the South. We're talking about northern cities, Washington, D.C., where I live, Minneapolis, Chicago. Where you hear about all these really terrible crime rates, you will find segregated cities and police departments that are not responsive to the public. And so one of the things that we've tried to do is identify what exactly the police are doing that are harming their relationships with the individuals. Because, again, with their communities, because if the community does not have the respect of the police, what incentive do they have to follow the law? Simon's absolutely right that so many of the people who do commit crimes commit it because they're impulsive, because of various issues, because of the segregation that I've talked about. That has a cascade of effects all through the community, because all of our public schools are geographically assigned, and it has to do with tax bases. So the schools within these segregated communities are separate and unequal. Again, according to the law, everything is fine. But according to what reality is, everything is not fine. And on top of this, the policing that happens in these communities is also separate and unequal. I'll give an example. There was a case a few years ago in our federal system called U.S. v. Gross. And Janice Rogers Brown, who is a recently retired judge in that system, She was one of the most libertarian judges in the United States. And she talked about this case, and she said, okay, she's talking about what are known as the gun recovery units in DC. So what these officers do is they're usually in plain clothes, but they're either in plain clothes or they're in tactical gear, like SWAT, basically looking like soldiers, helmets, guns drawn, and everything. And they jump out of cars, and they ask individuals to search them for guns. Now, the Fourth Amendment to the American Constitution says that you cannot be searched without a warrant, or the exceptions that the constitutional law has said, or probable cause. Otherwise, you need to get consent. I'm glossing over a lot of law here, but that's the basic general idea. Because the idea in a free society is you can be able to walk down the street and not be molested by the state to say, what are you doing, where are you going, and that sort of thing. And what she wrote in this case was, it was a concurrence of the opinion because she can't overrule what the Supreme Court said. And she's, what the government wants me to believe, I'm paraphrasing, what the government wants me to believe, and the Supreme Court says I have to believe, is that police officers in Southeast DC can jump out of cars, guns drawn, wearing tactical gear, and get affirmative consent freely given to search an individual for weapons. Now, she never mentioned race once in the entire opinion, but Southeast DC is predominantly black and poor and suffering all the issues, high unemployment, and the myriad issues that go along with segregation. She's like, okay, let's try a thought experiment. Try that in Georgetown. Georgetown is a white, posh shopping district in DC. She's like, try that in Georgetown and you tell me that's freely given consent. Because people in Georgetown can afford lawyers, and those lawyers will say, you are not violating my rights this way. And so what we have is separate and equal policing, which is theoretically unconstitutional. Yet this is the standard policy of the DC Police Department. And so what we've had is, as Simon alluded to in broken windows policing, there are limits to what that can do. Because what you have is police who are over-indexing on those areas, and they're very good at finding low-level offenses. And because the drug war has made officers looking, just because possession is a crime, that they try to get, like, search your pockets for drugs. They can make up reasons for searching you, and it becomes very harassing. And this is how people are treated in those communities. And yet, the police have become so good at that, like, low-level ticky-tack stuff, but when people get murdered, they can't solve it because no one wants to cooperate. You look at TV and you see that, Law and Order and CSI, that there's going to be a trial and there's going to be two lawyers going at it and there's going to be a forensic evidence that's going to, find the bad guy. That doesn't happen. Our system is 95% of all of our guilty pleas in the United States come from plea bargains. The court has nothing to do with it. There's no jury. So we've developed this system that has become very good at arresting people, very good at convicting people, but there's no justice here. And it has nothing to do with public safety because we're getting people for drugs. We're getting people for low-level offenses. Yes, we are getting violent criminals as well, and that's good, but they're not nearly as good at finding that. The number one reason for being arrested in the United States, simple drug possession. In 2016, more people were arrested for marijuana possession, not any other drugs. We have our opioid crisis, we've got meth, we've got all that issue. More people arrested for marijuana than aggravated assault, rape, robbery, and murder combined. This is a system that is looking to make arrests. Has nothing to do with justice. And so they've undermined the rule of law because the people who need the protection the most, the people who live in those violent neighborhoods, don't trust the police because they're shaking down their kids. They're stopping them on the street for no reason whatsoever, no legal reason. And the Fourth Amendment doesn't apply to them. How do you expect to make those people safer if they don't trust you? I don't know how it's expected here. I know in DC libertarians are not particularly fond of Black Lives Matter. But in actuality, they've done a great service for our country. As I said, we have 18,000 police departments. They run on, some of the big cities have like New York City has 35,000 police officers, but most police departments have, like half of police departments have less than 10 sworn officers. But they all operate on different state laws, different county codes, different police union contracts. And what Black Lives Matter did, they did a website called Campaign Zero. You can look it up. And they found every major city's union contract and like looked at how the police officers are held account for their misdeeds. Whether it's, you know, how long they're interviewed after they make a shooting. Whether it's, you know, whether or not they get paid while they're being investigated for misconduct. All of these things. It was one of the most libertarian things you can think of. It was crowdsourcing. It was trying to find all this information from disparate sources to try and hold the government accountable. But we look at them, so many people look at them and they're just like, they're troublemakers. You know, they're undermining the system. They don't care about America. They're being shot and killed on a regular basis, and no one cares. And when libertarians say, well, I don't care about identity politics, and I'll talk more about this in my next speech, beyond left-right politics, that what people hear outside of that is we don't care. And that is, I think, an unacceptable position for people who believe in liberty and believe in liberty for everyone. That people should have the rule of law protect them, that the Constitution applies just as much to black people as they do to white people, and that the government is as responsive to them as it is to the moneyed white people who basically make the rules in our country. So what we've got is a system that, and I salute Simon for talking about hotspot policing. I think it is great, but you have to be careful how you do it. Again, if you send police officers into those neighborhoods where crime is higher, what they do there is also important, because this is how the gun recovery unit sort of did its thing. Yes, Southeast DC suffers more gun crime than Georgetown does, but that doesn't mean the Constitution doesn't apply. And so if you send police officers there, yes, if that's where crime happens, send police officers there. But instead of sending them back downtown to do the paperwork on some guy who, you know, was on the street selling cigarettes, just say, you know, you can still hold order without using a cage as a threat. You can say, hey, we're going to be community police officers, and we're going to try and keep you safe. Now, if they see people breaking the law, they should do their jobs. But the fact of the matter is, if they're in the communities and they know that people are working with them, if, like, someone's selling drugs, but they, like, witnessed a murder, say, hey, you know what? I'm not going to run you in for this issue. I want to talk to you, and I want to protect you. And unfortunately, our system is not built for that. It's certainly not succeeding in that. So we have a bunch of inputs in here. We incentivize police officers to make high arrests. We incentivize them to seize money, and a lot of times they get to keep it. It's called civil forfeiture. And so much of this has to do with the drug war. If you're not looking for people holding a plant in their pocket, you can be doing things like solving robberies, solving murders, and doing the thing we expect police officers to do. But right now, doing it with the legacies that we've always had with racism, and that we have created this separate and equal policing regime, we need to change the policies, like ending the drug war, to stop doing this, and incentivizing police officers to protect and to serve, not to search and arrest. Thank you very much.
Thank you very much, Jonathan, for a very interesting presentation. We'll have time at the end of this session for some questions, but I just wanted to turn now to the academic on this morning's panel to talk to us about whose responsibility it is to uphold the rule of law. Many of us are talking about some of the issues in the rule of law, but one of the questions that I think is really interesting is whose responsibility is it? So maybe, Lorraine, you can explain to us whether it's Parliament's role or maybe someone else's responsibility. Whose responsibility is the rule of law, and who should be upholding it, who is not currently?
Well, thank you. It's a really great pleasure to be here, and Simon has effectively just given me a chance to do my talk in one sentence, so perhaps we can then all go and finish a bit early, which is basically, if it's Parliament's job, they're not doing it. So I might just stop there and give an academic world record for the shortest academic address ever. But I was really pleased when Tim invited me to be on this panel. He mentioned that the rule of law is a really broad topic, and we've got a really broad panel, and it doesn't really matter if the presentations don't really connect up. But Jonathan focused on the theme of trust and the trust between individual citizens and the police. And I wanted to carry that on and talk about the rule of law in terms of trust, being the trust between citizens and the Parliament. And it's one of the really important cornerstones of the rule of law, and something that I'm going to argue today is actually being systematically undermined through some systematic failures of Parliament as an institution to really do the job that we've entrusted it to do. And I do this with some hesitation because I notice there is a parliamentarian on the panel and some others in the room. So I should say everything I'm saying here is a generalisation and, of course, doesn't apply to Senator Stoker, who is brand new to Parliament and is carrying our hopes and dreams of a better future as she walks into the Senate chamber. What I wanted to do is focus on three elements of the rule of law because, of course, as a concept, it's a really nuanced, deep concept. And I wanted to focus firstly on the concept of universality. So the idea that nobody is above the law and everybody, even the government, has to abide by the law. Secondly, the question of transparency. So the idea that under the rule of law, every person knows that the laws are being made in an open and transparent manner. So Parliament makes the law in a public way. And finally, the question of knowledge. So the idea that under the rule of law, every citizen has the right to know what the law is, how the law affects them, and how they can comply with the law. So I'll argue that on each of those three measures, universality, transparency, and knowledge, there are some really glaring problems with the institutional structure of Parliament and the way that it's operating in present-day Australia. So turning first to universality, and Thomas Fuller said in 1733, "Be you ever so high, the law is above you," which summarises this concept very neatly. And I think the problem we have today is that far too many of our politicians give the impression, rightly or wrongly, that the law doesn't really apply to them and that they make the law for other people but don't really have to worry about it themselves. And I first started really thinking about this when I was talking about Section 18C, and I gave evidence before the Parliamentary Joint Committee on Human Rights during their freedom of speech inquiry with some of my colleagues at Murdoch University. And we gave evidence that Section 18C in our view is a immoral law. Section 18C in our view is a bad law, but even more fundamentally, Section 18C is an unconstitutional law. And I was really blown away when one of the committee members responded by saying, well, that's all nice, but that's the High Court's problem. It would be foolish for this committee to think that we could give an opinion about whether the law is constitutional. And now, to put it into perspective, I understand that the High Court is the final arbiter of constitutional issues in this country, but I had a funny sort of feeling that perhaps parliamentarians should be just a little bit interested in whether the laws that they're passing are actually constitutional or not. And maybe that's one of the things they should be thinking about. And it's simply not good enough, certainly in the context of 18C or any law, to say, well, there might be some constitutional problems with this, but we're just going to wait until one day down the track, maybe in a few years' time, some case will come up before the High Court and then we'll all know what the answer is. That simply isn't good enough. And that leads me directly to the question of Section 44 of the Constitution and the dual citizenship controversy. Over the past 10 months, we've had 15 of our parliamentarians either be ruled ineligible or resign preemptively due to concerns about dual citizenship and the constitutional requirements. And I strongly suspect that that number is going to increase before the controversy is finally put to bed. Now, regardless of your views on dual citizenship, regardless of whether you think this is a good constitutional requirement or a bad constitutional requirement, the fact is, it is a constitutional requirement. And it's not one of these implied requirements that the High Court kind of invents out of thin air. It's written in black and white. And so for our parliamentarians, for so many of them to have been caught out, seemingly giving no thought or little thought to whether these requirements apply to them, is actually really disturbing. And from a public's perspective, there's the view that, well, they want to make laws for the rest of us, but they're not thinking about whether they actually comply with the law as a starting point. When you add into that the fact that sorting out this mess has taken over 10 months and it's ongoing, it's been a protracted process, it's been a highly partisan process, we've had politicians continuing to sit in Parliament and resist referral to the court with every bone in their body, despite knowing that there were significant legal clouds hanging over their heads. That just undermines the trust that people have in their parliamentarians. And again, whatever your personal views are on Section 44, I think the biggest thing that this whole controversy has given rise to is an undermining of the trust that we have in Parliament as an institution. Because the rule of law, the idea that the law applies to everyone, including our politicians, has been undermined by the way they've dealt with the Section 44 issue. The second part that I wanted to focus on is the question of transparency. And that's the idea that the law is made by the representatives of the people in an open and transparent manner. And I want to focus on two examples of this that highlight some systematic problems with the rule of law. The first is the growing dominance of the executive in our political system and the undermining of the role of Parliament. And the second is the increasing tendency of government to avoid controversial issues by kicking the can down the road, which to my mind has rule of law implications. So to go firstly to the growing dominance of the executive, we all know that a key part of the rule of law is the separation of powers. So the legislature is meant to make the law, the executive is meant to apply the law. And now in our Westminster system, we accept that there is a fusion, certainly greater than, for example, the American system allows. But nevertheless, the executive is meant to apply the law that's made by the legislature. And there is meant to be that clear differentiation of roles. One consequence of the slim majority or even minority governments that we've had recently in Australia, and also of the growing or the rise of minor parties in Australian politics, has been a tendency or a temptation for government to avoid Parliament as much as possible and to instead govern through the executive, because it's a way of getting things done and doing what you said you were going to do. The problem with that is, I think it's fair to say now, the primary legislative arm of Australian government is no longer the Parliament. It's actually the Australian Public Service. And that has huge implications in terms of the rule of law. So, for example, the Federal Register of Legislation showed that in 2016 there were 102 acts passed by Parliament. It also showed there were 2,037 legislative instruments registered. So it's no exaggeration to say we've evolved into effectively a bureaucratic democracy. We're currently administered by 42 ministers and assistant ministers. They administer 53 portfolios in 18 government departments with 192 individual government agencies. And that's all run by, as of the 30th of June last year, 152,095 public servants. From a rule of law perspective, while obviously there needs to be a bureaucracy, there needs to be an executive, and all of this needs to happen, from a rule of law perspective, when you hand that much power to the executive, and really it's at such a scope now that it's impossible for the Parliament to retain sufficient oversight, it undermines the rule of law because we have unelected and unaccountable officials making decisions that affect our day-to-day lives, rather than having laws made in a transparent and open way that's accountable to the people who are meant to be served. Another example of this, or instance that undermines the rule of law, is the idea of kicking the can down the road. And increasingly, government in Australia is not an exercise of leading public opinion. It's not an exercise of making hard decisions. It's an exercise of trying to avoid damaging news poll slides and avoiding courting any form of controversy or offending any particular interest group. So it increasingly feels as though our politicians are trying to avoid tough decisions because they just want to kick the can down the road and avoid the problem until hopefully a magical solution arises tomorrow. Now, that's not limited to Australia. So, for example, one of the key reasons for Trump's success in America is that people actually felt he wasn't afraid to deal with the tough issues. He wasn't afraid of a bit of controversy. He was able to speak plainly about the issues that mattered to people, and people felt that he would make the tough decisions that needed to be made. When he drew a bright red line and that line was crossed, he'd actually respond. In Australia, the rule of law is undermined when parliamentarians don't face up to those types of decisions. So to give one example, and I think the same-sex marriage debate that we had in Australia really exemplifies this problem. Firstly, the decision to go to a plebiscite was made for political reasons rather than policy reasons. But more importantly than that, during the campaign, it became abundantly clear that there were serious concerns amongst a lot of Australians about the protection of religious freedom. And indeed, the Prime Minister made the claim during the campaign that he would, if same-sex marriage was legalised, ensure extensive protection for religious freedom, because he believed in religious freedom even more strongly than he believed in marriage equality. The problem is that no detail was provided. So we were asked to vote on marriage equality without being offered any detail about how those rights might be balanced with often conflicting rights, including the right to the protection of religious freedom. Instead, what the government decided to do was to appoint an expert panel, so to put off the decision for a number of months to allow an expert panel to consider it. And indeed, it hit a chord with Australians because they received 15,500 submissions during their short lifespan. The difficulty with that is that it's been over 6 months since Parliament actually legislated for same-sex marriage, and yet they haven't finished the job that they started, because they haven't even started to address the issue of how they're going to legislate or if they're going to legislate for religious freedoms. Instead, they're kicking the can down the road. And in terms of the expert panel, we've had the report given to the government as of last week, but there's no indication when that will be released into the public domain, when we'll have a chance to participate in that discussion, or indeed whether there'll be any discussion at all about actually protecting religious freedom. So regardless, again, of your views on same-sex marriage, whether you believe it should have been legalised or should not have been legalised, regardless of your views about whether religious freedoms are currently sufficiently protected or need further protection, the fact is we're not talking about it. And the laws that are being made in a manner that's not transparent and not open and undermines the rule of law because we're too afraid of ideas and we're too afraid to discuss controversial topics. And in our parliament, that has enormous implications for the rule of law. You also saw a taste of this in the recent Joint Standing Committee on Electoral Matters report into Section 44 and dual citizenship. One of the key recommendations of the committee was that we should put a constitutional referendum to the Australian people to repeal Section 44. And if that got up, we should then have a public discussion about what disqualifications we should have for our parliamentarians, and then Parliament should potentially legislate for some of those disqualifications. The problem with that is it gets things round the wrong way. It's putting the cart before the horse. How can you have a discussion about repealing Section 44 in a constitutional vacuum when you don't have detail about what's going to come? How can you be asked to even consider the issue when you haven't got in front of you the details about what disqualifications Parliament might enact after the fact? Again, we're kicking the can down the road and not engaging in the difficult decisions or the difficult conversations, and that has implications in terms of the rule of law. So the final aspect of the rule of law that I wanted to highlight in terms of Parliament is the question of knowledge. And that's the idea that in terms of the rule of law, everybody should actually know what the law is. How can you comply with it if you don't know what the rules of racing are? And the first difficulty here is simply that there are just too many laws, absolutely too many laws. It's impossible for any one individual citizen to know the full extent of the laws that apply to them. And I'd go so far to say that our parliaments are so overwhelmed with legislation that it's impossible for any individual parliamentarian to actually do the job they're elected to do and properly scrutinise each and everything that they're being asked to vote for. So on two levels, this knowledge requirement of the rule of law simply isn't being met. And in addition to there being too many laws, the laws that we create are too long and too complicated. So to give just one example, the Criminal Code Act of 1995 is 924 pages long. It contains 490 divisions. Now, to put that into a little bit of perspective, in itself that's too long, but let's keep in mind that's only one piece of criminal law at the Commonwealth level. And the Commonwealth doesn't even have primary responsibility for criminal law. It's actually a state responsibility. So the majority of criminal law is contained at the state level. how can an individual citizen know what they're expected to do? The fact that we're not all getting arrested here today is actually more good luck than good management, because none of us know what laws apply to us. Now, the 2016-17 annual report from the Office of Parliamentary Counsel gives us some insight into this, because it declares that the year 2016-17 was a very successful year for the department. How so? During the year, 217 bills totalling 7,638 pages were drafted. There was no discussion about whether they were good laws. There was no discussion about whether they achieved anything, but they were there, and that was the measure of success. That's a rule of law problem. Just to wrap up, the final thing that I wanted to mention, and the final example, was the environmentally sensitive area laws in WA, because these show that not only do we have too many laws that are too complicated, but we have laws that are made directly affecting individuals without those individuals even knowing that they're being affected. And this is one of the most egregious examples that I've come across in recent times. So there's a really complicated native vegetation framework in Western Australia. But what an ESA designation does is it says that the Minister of the Environment can issue a notice which declares your land to be an environmentally sensitive area. If that happens, you can't clear native vegetation from your area without a permit, and for individual landowners, permits just basically aren't ever granted. It affects about 90,000 properties in Western Australia and about 4,000 to 6,000 individual landowners, so it's a significant issue. In 2005, a notice was issued declaring all agricultural land, or all wetlands, in the agricultural region of Western Australia, environmentally sensitive areas. So overnight, by the stroke of a pen, the law changed. It was changed by the executive arm, but not to worry, because we were told in Parliament by the relevant minister that the department had given 7 days' worth of consultation before changing the law. They didn't actually consult with the individuals whose land would be affected. They consulted with the interest groups. And not only that, but they advised people not through notifying them individually, but through writing it up in the Government Gazette. Now, I'm probably the biggest constitutional law nerd in this room. Even I have better things to do on a Friday night than sit and read the Government Gazette. So the problem we have is that we've got a law that fundamentally affects your property rights that you didn't know was passed, and that it's really hard to find out about. That's a complete undermining of the rule of law. So in conclusion, the argument that I wanted to make today is that there, on a number of levels, are difficulties with the way our Parliament is operating. And just to finish off, it's something we should worry about, because if the rule of law is undermined, it affects the trust between individuals and Parliament. So what can we do about it? Is there a solution? I think there is, and the solution isn't more laws or more money. The solution actually lies in the room today. And it's this. In a democracy, we get what we ask for. So at the end of the day, if we want to restore parliamentary democracy through a truly Westminster-style parliamentary institution, we need to vote for politicians who actually believe in that, and we need to hold them to account once they get there to make sure Parliament is actually delivering the protections for the rule of law that we'd expect to see in Australia today. So I'll leave it at that, because I've been getting lots of wrap-up calls from the back, but happy to take questions at the end.
Thank you very much, Lorraine. Just make sure that you're getting your questions ready, and the way that you can do that is by opening up your Hoover app, if you've downloaded that to your phone, and making sure that you scroll down to the bottom of the Rule of Law section and add a comment or a question in there. Hopefully questions, so that they get read out and our panellists can answer them. And to answer all of the criticisms that were put from Lorraine, we've got our very own Member of Parliament here in Senator Amanda Stoker. Thanks, Senator.
I actually wasn't going to argue with an awful lot of what Lorraine had to say, and I hope that as somebody who's pretty new, I've got the luxury of doing that. I think I can tell a short story as an illustration of the mismatch between my expectations of what would be involved in the work of a senator and the reality day to day. And it was on the day that I was sworn in, they show you to your little office and things like that, and I've come in thinking, I really believe in the Senate as a state's house, and I really believe in it as a place that is about scrutiny and review of legislation. So I walk in there and I go, all right, where's the bills? And I was just looked at funnily by the public servant who was with me. You know, the bills for Parliament, House of Review, you know? Can I have the bills? And they looked at me like, nobody asks for the bills. What do you want those for? So they gave me a little eye roll that I'm sure they give to all the newbies, and organised some copies for me. Anyway, that's not what my talk is about today. It's about the subject of whether or not we should recognise Aboriginal and Torres Strait Islander people in the Australian Constitution. Because when this comes up, when the subject of Aboriginal people and their treatment and their lifestyles in Australia comes up, the conversation pretty quickly turns to constitutional recognition. Not the fact that there are abhorrently high rates of child sexual abuse in remote communities, or that joblessness and substance abuse are far too high, or that the infant mortality rate is somewhere between 1.8 and 3.8 times what non-Indigenous kids face. Instead, symbolic recognition is the wheelbarrow that the chattering classes are delighted to push as the panacea for all these things. There's a lot of different political perspectives on this, and so I'm speaking here for myself, not for the government or the parliamentary committees dealing with this. But that said, I'll be pretty upfront that I'm highly sceptical of proposals to dramatically change the Constitution to do this kind of recognition. It's not out of any disrespect. I'm sceptical because Indigenous Australians deserve better. It's pretty repugnant in a country where so many speeches begin with a long-form recognition of the traditional owners and the land on which we meet, that there's so little will to protect, to provide stability for or educate Indigenous children. It's the hollowest of gestures to insist on amending a document that is designed to allocate the responsibilities and powers of governments when Indigenous people continue to be overrepresented in the criminal justice system. It's the height of hypocrisy that vulnerable children are left in dangerous environments in some form of twisted prioritisation of cultural connection over basic safety and security in circumstances where any other Australian child would have been long removed. Thank you. And I know, Jacinta, you've been working really hard on this sort of stuff. You deserve to be acknowledged and honoured for that. You know that identity politics has gone too far when the fear of being called racist means that as a society we are reluctant to act in these quite dire circumstances. Now, you might think that action on these matters need not be mutually exclusive with constitutional recognition. And in a sense that's true, although there's an inevitable reprioritisation of awareness and resources that comes with dealing with multiple big issues at once. There's another good reason not to go down this path that also stems from a respect for Indigenous Australians, and that is that they are equal Australians and ought not to be treated as something lesser or other. I'll begin next by giving a brief history of the issue. You'll all know about the 1967 referendum to change the Constitution to delete the words "other than the Aboriginal race in any state" from section 51(26) of the Constitution, and to delete section 127. That succeeded, and it gave the Federal Parliament power to make special laws for Aboriginal people. It had bipartisan support, and it enabled laws that positively discriminate for Aboriginal people. Section 127 had until that time prevented counting Aboriginal people in the population statistics of this country. So those changes took the Aboriginal people from being excluded from citizenship and onto a neutral footing with the potential for action in their favour. In 1988, there was a Constitutional Commission report that also recommended Section 25 be repealed. That section contemplates a state disqualifying members of a particular race from voting because of their race. It recommended also that Section 51 sub 26 be removed and replaced by a clearer and more limited expression of the power to make laws with respect to Aboriginal and Torres Strait Islander people. It also recommended the insertion of a new section which would enshrine a constitutional protection from discrimination on the grounds of race, colour, ethnic or national origin, sex, marital status, or political, religious or ethical belief. Not much happened on that until we got to 1999, where the Howard government put a referendum to insert a preamble to recognise Aboriginal people as well as other values that were important to Australians, on the basis that it was to have no legal force. And it was defeated, with 60.66% of Australians voting no. In 2012, the Gillard government got a report from an expert panel which considered the issue, and the principles behind that examination were that any proposal had to contribute to a more unified and reconciled nation, be capable of being supported by an overwhelming majority of Australians from across the social and political spectrum, and of course, being of benefit and according to the wishes of Aboriginal and Torres Strait Islander people. It concluded that a preamble was a bad idea because of its potential for unintended consequences. It also recommended repealing Section 25 and Section 5126, but it also wanted to see a constitutional protection for discrimination and a recognition of Indigenous languages inserted. There's been more toing and froing in the Parliament that I probably don't need to go through in detail. I can probably skip to the Uluru Statement, which happened around July 2017. The Uluru Statement from the Heart came from a group of, which was supposed to be a representative group of Indigenous people, and it called for constitutional recognition, a mechanism for the voice to the Australian Parliament, and a Makarrata Commission. That's pretty much where the demands for recognition are at present. So I'll say something about each of those. It's worth noting, though, that this statement's been hailed as a really critical political moment because there was a level of consensus achieved that has never been before among Indigenous people. That's in part true. It's no doubt a cathartic moment for those who are present. But saying it's a unified position doesn't go much further than the platitudes. Not all Indigenous people were represented, and then substantial divisions emerge once we get down beyond the general statements and into the detail of what each of these items mean. It's highly aspirational, but it's low on detail. The Constitution changes it seeks are quite substantive rather than symbolic. The mechanism for a voice is not detailed. It's been canvassed as anything from being a third chamber of the federal parliament through to being local Indigenous councils with the power to manage local programs, through to a smaller committee of Indigenous people that stands in the shoes of the Minister for Indigenous Affairs. There seems to be little agreement about which of those should be preferred. The word Makarrata means treaty, and so a Makarrata Commission is also of unclear import, with views ranging from having a permanent truth-telling commission in which Indigenous histories are collected and honoured from the voice of the teller, without note to the law of evidence, for example, no testing for accuracy, not that I wish to suggest people would be dishonest, through to a formal negotiation for a treaty or a less political but formal history-gathering process. The stated purpose of the Commission is to help with the healing of past wounds, though one could query the value of a permanent self-flagellation commission in generating any kind of healing. It's worth observing too that there was no meaningful consultation of non-Indigenous people in the process of coming to the Uluru Statement. That itself has to be a significant limitation, because if you haven't brought non-Indigenous Australians with you, any proposal will struggle to succeed. So I've said something about the voice already. There's a few good reasons why that should be treated with scepticism. A process of segregating Indigenous people from political life, where we already have quite a functioning system with a number of effective and impressive Indigenous people in the Parliament, seems to me to violate this fundamental principle of equality that should be non-negotiable for Australians. I imagine it'd be expensive, though of course no one's provided any numbers on the fact. And it has to amount to a further barrier to the productivity of Parliament, particularly if it has a formal veto power. But even if it's an advisory role, the impact of having a publicly funded body of people dedicated to operating permanently as an informal approval mechanism has to operate as an obstacle to productivity. The idea of having an elected Indigenous person or a committee of Indigenous people who are to work as the Minister for Indigenous Affairs might have potential, but funnily enough, this has got the least amount of discussion in the public debate so far. If we consider local community elected bodies designed to take greater responsibility for program delivery in Indigenous areas, particularly in the really remote places, that might have some potential, but the risk will always be to ensure that it doesn't end up reflecting the corruption that led to the abolition of ATSIC. A potential strength, though, is that it encourages local communities to take responsibility for the outcomes for their people, rather than expecting problems to be solved from afar. The financial sustainability of these programs, however, will always be a matter of concern. It has to be better for democracy for Indigenous people to be represented in the ordinary parliament as equal Australians, rather than something different or other. Operating on the presumption that all Australians aren't equal has to be toxic. And even if you're of the view that Indigenous Australians aren't currently treated equally, these moves would entrench that view rather than aspiring to getting it right and having a system that's flexible enough to adapt to it. A Makarrata Commission has huge problems for getting the majority of Australians on board, probably because, for the reasons I've mentioned earlier, it has a potential to descend in permanent victimhood status. If it's to lead to a treaty, as some would say, there's a further problem about what that treaty means. Is it to be an avenue for compensation of a financial kind for those who are from the families of people who have suffered past wrongs, or is it merely symbolic? The risk is that you might agree to it on one basis and find that it does another. Also, treaties are something you sign between nations. Signing it with a part of Australia has to be divisive and suggesting that Indigenous people aren't among us. I think preambles have probably been considered and dismissed based on the fact that Australians have rejected it already. Can I say how firmly we must resist the insertion of a broad anti-discrimination provision under the guise of being kind to Aboriginal people? The debate around Section 18C over the past couple of years has to show that these provisions, even when they're legislative, have perverse consequences and are almost always hijacked by the left with its obsession with identity politics. To entrench that in a constitutional form would just be, in my view, disastrous. But there are things we can do. It's not all negative. We can delete Section 25 of the Constitution. It's plainly discriminatory and reflective of a time in which it was seriously a risk that state parliaments might try and deny Indigenous people the vote. We could delete Section 51, sub 26, or revise it down to a minimalist form. Deletion is the philosophically better position because it's based on the principle that all Australians are equal. But there's a lot of Commonwealth legislation that depends on the existence of the power, such as the Native Title Act. It may be more achievable to pare it down to the very minimum required to sustain that legislation and no more. And we could legislate for local consultation mechanisms without entrenching them, so that if they become plagued by the kind of problems ATSIC faced, it could then be reformed. And if we reach the point where we had closed the gap, then it could be abolished as a sign of ultimate accomplishment. Ultimately, in concluding, we should return to both the principles of equality for all Australians and return to the purpose of a constitution. That seems to be lost in this debate. What are constitutions for? Well, it's not a document that's designed to make people feel good or loved or healed. It's not a psychological panacea. It's a document to allocate the responsibilities of government and set up the mechanical structures of the nation. If we expect constitutional recognition of Indigenous people to solve the myriad of social problems that they face, we will be sorely disappointed. Thank you very much.